This video will give you an overview of the freedom of information regime that we have in Australia. Why have freedom of information laws? These are seen to be a fundamental part of open democratic government. So the idea is that government should be transparent and accountable. So FOI legislation is designed to enhance that transparency and accountability of government decision making, of service delivery, and of general the policy and administrative goings on of our government. The idea behind this is that a better informed community is better able to participate in the nation's democratic processes. As well as these more lofty goals, the FOI regime provides a mechanism for individuals to see what information is held about them personally by the government and to seek to have that information corrected if it is incorrect. Finally, the FOI regime recognises that the information gathered by government is done so at the public expense, so through our tax dollars essentially, and therefore that information should be available to the public that has funded it. Under federal law, the Freedom of Information regime is governed by the Freedom of Information Act 1992, and the reasons for the legislation are contained in Section 3, which is the objective section of the Act. So the laws we have in Australia, as I mentioned, the Act which governs FOI relating to the Commonwealth Government is set out in the Freedom of Information Act 1982, and this is administered by the Office of the Australian Information Commissioner. The Australian Information Commissioner works from that office. That office also contains the Freedom of Information Commissioner and the Privacy Commissioner, and they have a staff to help them administer the relevant acts. There are also state-based freedom of information regimes in Queensland. This is governed by the Right to Information Act and the Information Privacy Act, both are 2009 acts. And these are administered by the Office of the Information Commission Queensland. But for the purpose of this video, we are going to focus on the federal legislation. There are several principles that underpin this legislation, and they are that all members of the public enjoy an equal right of access to government documents. And what this means is that an applicant under the FOI regime is not required to give reasons for requesting a document and is not required to demonstrate any special need for that document. They have a right to access that and to request access. This is a legal right. A government agency or a minister has no discretion to deny that access right except as dictated by the FOI legislation. So there are certain sections in the legislation which provide grounds for refusal or provide that some documents are exempt from the regime, and we will look at those in a moment. But except for those reasons contained in the Act, an agency or government cannot refuse that right of access to a person requesting it. If a person is denied access to a document, then they have a right of appeal. For that decision, they can appeal to an independent tribunal, and then that can also be passed on to the federal court, and we'll look at those rights of appeal later in this video. Other principles are that at all stages of the regime, the onus falls on the government agency or minister to show that their decision to grant or deny access is justified. So both in the initial decision and through review, the onus of proof is always on the agency or the government. Agencies must also publish information, generally these days over a website, that explains their powers, their structure, their decision-making processes, and also their FOI processes and guidelines. And the final principle is that even if the FOI Act provides that a document is exempt from the FOI regime, then an agency or minister may still provide access to that document unless there is another act or piece of legislation that prohibits it. And that will usually be that it is secret because of national security reasons. And again, we'll look at that in more detail soon. All right, so the main section in the Act which provides access is Section 11. It provides that every person has a legally enforceable right to obtain access to a document of an agency or an official document of a minister, unless that document is exempt. Importantly, the Act refers to person, and that is considered to have a broad meaning. So a person does not have to be an Australian citizen or an Australian resident to rely on the Freedom of Information Act. And a person will also encompass a company or an organisation. They can also request access under the Act. So let's break this down a little bit further. We need to look at the meaning of document, the meaning of agency and minister, and the exemptions under the Act. So firstly, what is a document? This is defined broadly to include paper documents, but also electronic documents or electronic information. It may include photographs or drawings, and it may include audiovisual items, so sounds, images, or writings that are captured in digital form. This extends to personal correspondence, such as emails, to diaries and calendars, to other information stored on computer hard drives or servers, to laptop computers, and to portable storage devices. It applies to a document held by an agency. So that document may have been created by the agency, or it may have been created by a third party and received by the agency. But so long as the agency has possession of that document, then it is subject to the FOI regime. What is an agency? This is mostly common sense. It will be most Australian government agencies. Again, under the Federal Act, we're looking at federal government agencies. Some agencies, though, are expressly excluded. One important one is the Australian Security Intelligence Organisation, or ASIO. This is our national security organisation, so that is exempt from the Act. Some agencies are only partially exempt in relation to particular documents or particular actions. So, for example, Australia Post and Medicare both have government functions, but also commercial functions. And in relation to their commercial activities, they are exempt from the FOI Act. All agencies are exempt in relation to intelligence agency documents and defence intelligence documents. So these include documents around national security and defence strategy, essentially. Who is a minister? The Act also applies to ministers, and ministers and their officers are treated as being separate from the departments in which they work or for which they may be responsible. So a minister's office is responsible for processing FOI requests that are directed to the minister, and this applies also to parliamentary secretaries. The Act applies to an official document of a minister. So with ministers, the definition of document is a little narrower. It must be an official document. This essentially is documents related to their official functions as a minister. So it won't be personal documents or any documents of a personal nature or any documents related to their that have a party political nature. So documents related to campaigning and that sort of thing. Minister is only a current acting minister, so a request cannot be made under the FOI Act to a former minister. All right, the requirements for making FOI requests. So there is a process that a person must follow to make a request under the FOI Act. Firstly, the request must be in writing. Many agencies on their website will have a template that they use or a pro forma that they use to make that simpler. So you simply fill out that online form. The request must state that it is an application made under the Freedom of Information Act, and it must describe the document that is being sought. Now, the document does not have to be described precisely, but the request must provide enough information to allow a person to reasonably identify the document that the applicant is seeking. The request must provide a postal or email contact address where the agency or minister can send notices. And naturally, the request must be lodged. So it must be sent to the agency either by post, hand delivery, email, or online lodgement. Once an agency receives a request, then they have a duty to provide reasonable assistance to a person to make sure that that request fulfills those 5 requirements I just outlined. If they receive a request that seems like it's not really for their agency, that it's for another agency, then they must also provide reasonable assistance to help that person direct their request to the appropriate agency. If the agency might decline or refuse the request because it either does not adequately identify the documents being sought, or for practical reasons, which we will discuss soon, then the agency also has an obligation to work with the applicant to see whether they can essentially fix the faulty application. So whether the documents can be properly identified or the scope can be narrowed of the request so that it will not be denied for practical reasons. The Act imposes timeframes on the agency or minister for fulfilling requests to access. Once they receive an application, they have 14 calendar days, so that's not business days, calendar days, to notify an applicant that the request has been received. And then they must make a decision about that request within 30 calendar days of receiving the request, and communicate that decision to the applicant. If they do not do that within 30 days, then the request is deemed to be refused, and the applicant may seek review of that refusal with the Information Commissioner. If the agency grants the application to access, then they must provide access to the documents as soon as reasonably practical. It is possible to extend this 30 calendar day timeframe through agreement between the parties and consultation, or if the Information Commissioner decides that this is a particularly complex request that it needs more time, they may also grant an extension. If the agency has had to go through the process of helping the applicant to refine their request because it was too broad or not specific enough, then the time frame may also be extended. All right, so why may an agency refuse a grant? Under Section 24 of the Act, they may refuse a request for practical refusal reasons. And this is defined to mean if the request would substantially and unreasonably divert the resources of the agency from its other operations, or it would substantially and unreasonably interfere with the performance of a minister's functions. Another reason why it might be practically refused is that their agency has looked everywhere for the document and it cannot reasonably be found, or they are satisfied that the document does not actually exist. Now, the agency or the minister, before issuing a refusal for practical refusal reasons, is supposed to undertake a request consultation process. This essentially means contacting the applicant and trying to work with them to narrow the scope of their application so that it will not be denied because it is too big and would unreasonably divert the resources of the agency to fulfill it. Right, so this is talking about the staff that would be required to spend their time on this process, the investment of resources, etc. If that is going to be too big and take too long, it might be refused, but not before the agency works with the applicant to try to make this a more reasonable and practical request. An agency may impose charges on an applicant to access documents to cover things such as photocopying and postage or for staff time and resources. But importantly, the first 5 hours of that time and resources are free. And there are regulations that impose maximum charges. So an agency or minister should try to impose the lowest reasonable cost they can. And in any event, they cannot go above the maximum charges that are set out in the regulations. All right, now there are some exemptions to FOI requests for access. Documents may be absolutely exempt, and these are usually documents that deal with national security, or documents may be conditionally exempt, and this is where access is conditional upon meeting a public interest test. So let's go through those. Exempt documents are not required to be disclosed in response to an FOI request. They may be disclosed, but they are not required, and that can simply be a refusal based on the document being exempt. And on the slide there is a list of the kind of documents that are exempt. As I mentioned, these include national security and defense related documents. Also includes cabinet documents or documents that are subject to legal professional privilege. And it includes documents that contain confidential information or trade secrets. It includes electoral rolls. And it includes documents that essentially might raise other legal concerns, such as the disclosure would be in contempt of Parliament or court. Or documents that might affect law enforcement or disclosure which might prejudice public safety. Other documents might be conditionally exempt. That means that they are exempt unless it is, they should be given access unless it would be, disclosure would be contrary to the public interest. So the agency or minister must consider whether it is actually in the public interest not to disclose this document. And again, on the slide, I have a list of documents that are conditionally exempt. These are ones that concern personal privacy or the financial or property interests of the Commonwealth, that affect Commonwealth-state relations, internal working documents, documents that affect Australia's economy or business affairs, or relating to research of specified organisations. So as I mentioned, if a document is conditionally exempt, the decision maker, so the person deciding whether or not to grant access, must apply the public interest test, which means that they must weigh up reasons for and against disclosure, always keeping in mind that what they are weighing up relates to the public interest. So this is so the factors that they must take into account when deciding public interest are whether the access to the document would promote the objects of the FOI Act, whether it would inform debate on a matter of public importance, whether access would promote effective oversight of public expenditure, and whether access would allow a person to access his or her own personal information. What they cannot consider when deciding whether access would be in the public interest is whether the document would cause embarrassment to the government or cause the people to lose confidence in the government, whether somebody might misinterpret or misunderstand the document, whether the document relates to somebody who is high in seniority in the government, or whether access to the document could result in confusion or unnecessary debate. So these are not permitted to be taken into account when considering public interest. So if an agency or a minister decides not to grant access, then the applicant may apply to have that decision reviewed. They can appeal to the actual agency, or they can appeal up to the Information Commissioner. The Information Commissioner may also apply to the Administrative Appeals Tribunal for review of the decision. So the AAT is not a court, it is a tribunal, which is kind of like a lesser, less formal version of a court, which is easier to access and is much faster than a court. But if the matter turns out to be particularly complex, then the AAT can actually refer the matter up to the Federal Court of Australia. The Australian Press Council and many journalists have identified a number of problems with the FOI regime in Australia. They claim that it is time-consuming and difficult and costly. So often the claims are that agencies actually take longer than the timeframes designated in the Act to make decisions, or that they rely particularly on the practical reasons refusal to deny permission to access certain documents. And the complaint is also that too many documents are exempt from the FOI regime. So this is a regime that is under pretty constant scrutiny and is likely to perhaps be reformed in the future. Thank you.